So as Paul mentioned, we opened a consultation on the 9th of January on Awaab's law. It'll be open for 8 weeks, which means that it's going to be closing on the 5th of March. So we're about halfway through that consultation period. And what we're trying to do is really seek views on some of the proposals we've set out for how Awaab's law should work in practice. So we have 8 kind of key proposals that I'd like to talk you through today. And I'll just run through that in a bit of detail and set out some of the questions that we're asking in the consultation. So just in terms of background, as Paul mentioned, Awaab died in December 2020 as a result of the mould in his social home. A campaign was launched calling for Awaab's law in 2022, so following the coroner's report into his death. This was led by Manchester Evening News and Shelter in collaboration with the Ishaq family. And what that campaign was calling for was for timelines to be set for landlords, social landlords, to investigate and fix hazards when they're reported in the home, specifically focused on damp and mould. In terms of kind of what we've done since, in the Social Housing Regulation Act, which was going through Parliament, we introduced an amendment to be able to introduce Awaab's law, and that legislation achieved royal assent in July. And now what we're looking to do is look at the actual specific details of how the legislation should work and the requirements that should be set for social landlords. In terms of how Awaab's law will work, it will do something called imply terms into all social housing contracts, which essentially means that your landlords will be bound to meet these requirements. And if they don't, you'll be able to take them to court for a judge to take a decision on whether they have breached Awaab's law or not. But alternatively, tenants will also be able to go to the Housing Ombudsman to raise complaints if they feel their landlord has not met the requirements under Awaab's law. There are a few things that we want to talk to you about today. One of them is around the scope of Awaab's law. So the original campaign called for Awaab's law to apply to damp and mould hazards. Obviously, that is why Awaab died and what the campaign was originally calling for. However, we propose that Awaab's law should apply more broadly to any type of hazard that might affect you in your home. We propose linking it to something called the Housing Health and Safety Rating System, which sets out a list of 29 hazards that could affect you in your home. So that ranges from things from excess cold to electrical safety hazards. And we think that if there's any type of hazard present, that Awaab's law should apply and your landlord should have to take action. So this does broaden the scope beyond just damp and mould. And we are seeking views on whether people agree that we should use that broader definition when we think about Awaab's law and the timeframes that will be introduced. So the first main proposal that we have set out in the consultation is around what landlords should do when they're made aware of a hazard that might exist in the home. So that could be whether a tenant has reported that to them, either sort of formally written or called in, or mentioned it to a housing officer, or whether the landlord has become aware of the hazard themselves through other repairs that they were scheduled to do, or for example coming in for their annual gas safety check. Our proposal is that if landlords are made aware of a hazard, they have 14 calendar days to investigate, which means to come and assess whether there is a hazard or not. We are expecting landlords to take account of who is actually living in the property and any vulnerabilities that they may have to then decide whether there is a hazard. So something that may not pose a hazard to a group of 30-year-olds living in a house might pose a hazard to a family with young children, for example, where the door being broken on a main road may present a greater risk. So one of the things that we are really seeking views on is whether people agree with that 14-day time frame, which is what the campaign called for. And one of the things we also want to get a sense of is whether people feel that medical evidence should need to be provided if there is a vulnerability that needs to be taken into account. This was something the campaign suggested, that tenants should provide their landlords with evidence of any medical conditions, but we feel that this might slow down people's ability to kind of get their complaint looked at, and we also think it will probably put a significant burden on GPs. So our proposal is that tenants don't have to provide any evidence of medical conditions, but they can of course share that with their landlord should they want to. So that's another point that we're kind of interested in views on. Our second proposal is then what should happen after that investigation has occurred. And we're proposing that social landlords need to provide the residents with a written summary of the investigation within 48 hours of the investigation taking place. The summary will need to sort of set out if a hazard was found or not, and if a hazard was found, what that hazard is, and what steps the landlord will be taking to address that hazard and in what time frame. So we are kind of seeking views here on whether people agree that a written summary should be provided, that those are the minimum requirements of what needs to be provided in the written summary, and also with the time frame. So whether it should be within 48 hours, of the investigation having concluded. Moving on, our third proposal is around what a landlord will need to do if they do find a hazard. So again, in line with what the campaign called for, we are proposing that landlords should have 7 days from the time of the investigation to begin repair works if they do find a hazard in the home. Within that, we think that measures that are needed to make the property safe should be taken as soon as possible. So, for example, in the case of damp and mould, that might mean that the mould spores are removed immediately within that 7 days, and then further repair works are booked in to address the underlying causes of the mould, for example, whether there are structural faults or whether additional ventilation is needed in the property. So again here, we're seeking views on that time frame, so whether it's within 7 working days, whether that feels appropriate to you, and whether people do agree that in instances of damp and mould, the registered provider needs to take action immediately to remove the mould spores before they then plan in the kind of wider repair works. We also are seeking views on whether people agree that this timeframe should refer to repair works beginning. We don't think it is feasible to set a deadline for when the repair works need to be completed, because it really will depend on what the hazard is and the scale of the issue. So it could range from the repair works can be done and completed in a day to it will need to be several months because of the fact that it's a significant structural issue with the property. But we are seeking views on that, and it'd be really interesting to get people's feedback on that point. The next proposal does refer to then when should the repairs be completed. So as I said, we don't propose setting a firm time frame, but we propose to set in legislation that landlords will need to complete repair works within a reasonable time frame, and that they will need to communicate that to the resident. So what do we mean by reasonable? It's a bit of a how long is a piece of string, but what the landlord will need to take into account will be the nature of the problem, the proportionality in terms of like the scale of the repair, how much work is required, and also the needs of the occupants. For example, who lives there, how quickly do they need to address it? Our fifth proposal relates to emergency repairs. So this is when a landlord comes in and they've identified there's a hazard, but it's such a severe hazard that it poses a significant and imminent risk of harm to the people who are living there. We set out some examples in the consultation of what this might look like. So, for example, a boiler being broken in winter, there being an electrical wiring risk, something where it is reasonable to believe that in a short period of time that could cause harm to the health and safety of people living there. So separate to the sort of 7-day time frame, we're proposing that where an emergency hazard is identified, landlords should have 24 hours maximum to address that, and they should be acting even faster where possible. So again, we're seeking kind of views on whether people do agree that we should be setting a separate time limit for emergency hazards, and whether 24 hours is the right time frame for those hazards. Our sixth proposal regards what happens if the landlord can't make your property safe within the 7-day time frame. Our proposal is that landlords will need to offer suitable alternative accommodation to residents if they cannot make the property safe to live in. It will be an offer. They won't be forcing residents out of their homes if they don't want to, but it will be recognising that in some instances, for example, mould may be so pervasive that it's not possible for them to simply wash off the mould spores, that they'll need to do something much more drastic, and it wouldn't be safe for the resident to remain in the property. In terms of what would alternative accommodation look like, it could include vacant stock that your landlord has, a vacant home or flat. However, it may also include a hotel if that is the only option available to them. We will be clear that this needs to be a short-term solution, but we are interested in views on whether residents agree that landlords should have an obligation to decant you, offer you a suitable alternative home, and for the short term at their expense if your home can't be made safe. Our next proposal is really around the obligation on the landlord to keep records of all their attempts to comply. So any correspondence they may have with residents and with their contractors. And this is really so that should a case go to court, they would be required to provide evidence that they had tried to contact the resident multiple times, for example, to gain access, or to demonstrate that there was absolutely no way they could do the repair in those timeframes because they couldn't find a contractor, for example, who was available to do that. So this is really about an onus on the landlord to keep records as a sort of defence should any kind of case be brought in court. So the question there is really whether people agree that we should provide provisions for a defence, that a landlord has taken all reasonable steps to comply with Awaab's law, but it wasn't possible for them to comply with the timeframes because of reasons outside of their control. The last page just sort of sets out the link to the consultation, how you can complete it via an online survey, as well as our email address and our address for any written responses that people may want to submit.